Let's get into one that I also don't think I understand the logic to. It's the Epic Games Fortnite versus Apple. We covered it. We talked about it a while back. Epic was suing Apple for a number of things: antitrust violations, breach of contract. Basically, fact pattern for anybody who doesn't know, Fortnite, very popular game. You had these in-store purchases. As you play the game, you can buy stuff. Any in-store purchase had to go through the Apple App Store, and Apple charges 30%. And it was sort of a baked into the contract between any app developer. It wasn't just Fortnite; it's everyone. Sell on Apple. Your sales, your in-store app purchases have to go through Apple. Apple takes a 30% cut. Fortnite got so popular, numbers are astronomical, but it doesn't matter. They decided to basically bypass Apple, try to make the sales direct through their own store, bypassing Apple, and not either they were charging a premium or they were just charging a discount to sell whatever in-app purchases that were offered through the game that would otherwise have to come with a 30% premium that goes to Apple. Apple then terminated them, said breach of contract, we're cutting you out of the App Store, and then Epic sued Apple, and they got a final judgment. It's a first instance lower court judgment. The judgment is sort of like Nick Rekieta did a decent analysis where he was viciously attacked by the biggest wasp he had ever seen in his life. I think he's trying to imitate my fear of wasps. I'm joking, but he did analysis, said it's a win-win, but it's a lose-lose. Both parties lost. Basically, Epic. Oh yeah, in the interim of this, there was an agreement between Epic and Apple, and it said if Epic loses, they're going to put money in escrow and they're going to pay 30% of whatever their sales were during the litigation process. And they made something like $12 million in sales, so they're going to have to pay 30% to Apple. That was the loss, because basically, you'll tell me, I don't know how the judge sucks and blows at the same time, but I think they do. They said Epic breached the contract with Apple. It was in there. They weren't allowed to do it. There was no antitrust violations. There was no monopolistic behavior. Even though Apple has 55% of the market share, it's not monopolistic, and they can't be penalized for their success. So they were within their rights to terminate the contract, but at the same time said under California law that Apple was engaging in unfair business practices by baking into their contract the fact that these app developers could not use workarounds to directly contact their own clients, their own users, to offer things for sale. So you're going to have to clarify for me how the judge said basically there was a breach of contract by Epic such that Apple was within its rights to terminate, but the terms of that agreement that Apple enforced were themselves in violation of California law, and they are permanently enjoined from imposing those terms of conditions as contractual obligations on a going forward basis.
Yeah, so I mean, what she did is she gave Fortnite what they really had to have, but not what they wanted to have. So what they had to have was the ability to sell directly to their consumer without having to give Apple its 30% all the time. And she just found a creative way to give them that. She went under the California unfair competition law, which is very broad, rather than the antitrust laws. She didn't give them what they wanted in big, which was to say this is a monopolistic practice and should be stopped altogether. She didn't go there. Now, what she basically said is that Apple and Google have a duopoly because they have over 90% between the two of them. To me, the old understandings of monopoly, what Apple's doing is a monopoly. And so a lot of people from the monopoly side were disappointed in the ruling from that side. However, the developers were still mostly happy because what they want is some means to get out of this control by Apple into perpetuity. It's like people who got a local subscription initially. If they got it through an Apple phone, they paid $7 rather than $5. And I was like, well, what do you mean you paid $7? I was like, oh, you went to the phone. That $2 that went to Apple. That's what that was. If you do it online, it was only $5. So so that was causing a problem for a lot of developers. So she gave a big boost to developers ultimately, but she didn't give the death nail to Apple that it feared. So that's where it was very much a Solomonic split the baby outcome.
And so and it was only under California law. So Epic was asking basically for a global injunction. They said no, only under California law. Is Apple going to change?
Apple's based in California, so it applies to everything they do anyway.
Okay, so there's no way they're going to change their choice of law, their venue out of
It'd be tough.
California.
I mean, they could try. They could try go on a go forward basis, but there's issues with them trying that path. Same with Google. I mean, the thing, all the big tech companies are in California, so they all have to. This will likely apply to them, and trying to get around it will be tricky.
Okay, interesting. But now, so they enjoin Apple from doing it on a going forward basis, or enforcing it in their existing contracts.
Enforcing in their existing contracts, but also that they have to make accommodation to allow the developers to be able to circumvent Apple in going direct to their consumers. So that was the big financial bonus to all the other developers. Yeah, there's people who don't like both Apple and Epic.
Yeah,
the impact on this is mostly smaller developers now that don't have to kick back to Apple all the time.
So I mean that's very funny. It's like Epic has gone through the costs, through the litigation. They're going to have to pay 30% of their 12 million, and every other independent app developer is going to reap the benefits of what Epic did, but not Epic itself. Although the question is going to be, does Apple let Epic back on, given that it was ultimately very financially beneficial for both, or is Apple going to maintain their deplatforming of Epic to their own, to cut their nose off to spite their face?
I think they wanted to send a message, but since they lost a key aspect, I don't know if they'll continue that path or serves their interest to continue that path.
But is it as big of a deal for Apple as one thinks? Now it's basically
it is because it's a substantial change in their ability to exercise what I think is their monopoly power. It's just considered unfair competition rather than monopolistic.
And now, the bottom line is it's going to allow app developers to basically gather user information and contact them directly without going through Apple.
Yes.
Whether or not they can do that as efficiently as they can by using Apple, fine. So maybe it's the best of both worlds for everybody, but in theory could cost Apple a little bit of money.
It's gonna cost Apple a lot of cash over time, and empower a lot of your smaller developers, particularly for whom those margins to Apple were crushing.
Does Apple appeal? Do they think of appealing, and do they have a grounds of appeal?
I know there's risk. I think there's risk for both sides appealing. So the nature of her ruling would be hard to overturn, except on the monopolistic side in part, because that's really a legal determination. So Epic would have a stronger appeal than Apple.
Does by the way, if for anyone listen, I skimmed through the judgment because it was 185 pages. But does this one thought that I had? Does this encourage anybody to go to file suit against YouTube or any of the other social media platforms for violating California law? Because California business laws seem to be very favorable to the consumer, to the weaker end of the business relationship. Is this going to inspire them to take suits under similar bases against YouTube, Facebook, and Twitter?
They've always distinguished between contract relationships and consumer relationships. So when they're vendors is when they hold big tech accountable. When it's consumers, it depends on the grounds. If it's something like privacy or CP or something like that, they are allowing suits to go forward. For pure censorship issues, it's going to depend on additional state law provisions. And that's probably a good transition into the Texas new anti-censorship law that just passed this week.